Okay, welcome everyone. Thank you very much for joining us. I'm Todd Brower. I'm the Judicial Education Director for the Williams Institute at UCLA. And I'd like to thank the organizations that are sponsoring us, the Williams Institute, of course, and the International Association of LGBTQ+ judges. I'd also obviously like to welcome and thank our panelists for being here. We have a terrific panel today. We have Judge Catherine Kate Chilton from LA Superior Court, and Judge Dean Hansel also from LA Superior Court, and Justice Luis Lavin from the Second District Court of Appeal, which sits here in Los Angeles. I'm not going to do the bios for the judges because part of their story and how they got to court and when they were appointed is in fact what I'd like them to talk about. So perhaps the first time you speak, judges, you might mention those things. For those people in the audience, we're going to be taking questions at the last 10 minutes or so. If you have questions during the presentation, please put them in the Q&A window, and we will discuss them at that point in time. Then this webinar is really part of the Judicial Mentorship program. And I'd like to turn it over to Dean Hansel to tell us a little bit about the program, and then we'll start.
Great. Thank you, Todd, and thank you both to the Williams Institute and the International Association of LGBT Judges for sponsoring this. The Judicial Mentoring Program is an outreach program that started in Los Angeles. We were asked by the governor's office to undertake a program that's now been rolled out statewide to meet with people in different organizations that are considering becoming judges, and others that are just curious and might not before the conversation consider it, but after they hear about it to do so, so that we can really try to develop a pipeline of attorneys who come from very diverse backgrounds, who might be interested in considering a career on the bench after they've been attorneys. And it's divided into two parts with it. It's the actual mentors and people, participants in it, who need to be attorneys more or less 10 years out and older than that. Would get assigned a judicial mentor. It might be in the county in which they're applying, and it might not be. The purpose of it isn't really to have somebody who becomes an advocate for you, but really somebody that can help provide advice for you along the way. And we have well over 100 judges now that are judicial mentors, and as it gets rolled out further statewide, that number is going to grow. Then there are a small number of people, myself being included, that are members of the apparatus that helps choose judges. In my case, what's called the Judicial Selection Advisory Committee. It's a group of judges and attorneys selected by the governor, and we review applications for the bench, and we make assessments about people recommendations, and then those go back to the governor's office. So the group of us that are in that category cannot be mentors to people, but that doesn't preclude us from talking in a group like this about what the process is to do it and how to become a judge. And the other part too is really to disabuse sort of myths about it too. Some people decide not to apply for certain barriers that really are not barriers. And that's the other thing we'll want to talk about with you this evening.
Thank you. That's really useful. Since this is sponsored by the LGBTQ+ Judges Association and Williams, I wonder if we can start with how many openly LGBTQ judges there are. Justice Lavin, other than yourself, if I may out you that way, how many appellate court justices do we have here in California?
Just 5. We have 112 appellate justices sitting on the courts of appeal and on the California Supreme Court. We have one, Marty Jenkins, who's on the California Supreme Court, and then there are 4 of us sitting throughout the state. So it's less than 5%. So 5 out of 117 out of 112.
I see that. Judge Chilton, I wonder, can you tell us about Superior Court judges? You've just been, you've just taken the bench, so that would be interesting from that perspective.
I've only been on the bench for about 5 months, so I don't have any good facts and figures at my fingertips, such as how many LGBTQ judges we have in the Superior Court, but I know that Judge Hansel definitely has that information, so he can provide that.
That'd be great.
And right now, of course, we don't know everybody because of the fact that some people choose not to self-identify. But statewide, right now we have about 100 LGBTQ judges, and there are, I'd say, of that, roughly about 2/3 are male. 1/3 are female. We have a grand total of 1 trans judge right now. That's it. It's a huge priority for us. And I might note, in the final years of the Brown administration and into the Newsom administration, that the numbers have increased. So we've got a steady supply, and I know also just from looking at applications. Right now, we have a sort of a nice number that are going through the system, but there can always be more.
So that's actually gives me a nice follow-up question. So how is membership in the LGBTQ plus communities, how is that viewed? As a positive, as a negative, as neutral?
Well, certainly, I think from the points of view I know it's viewed as a positive in this sense that one of the most important things that Governor Newsom is looking for are judges that are not just smart and hardworking and ethical and have a commitment to public service and so forth, but people that are empathic, that have the ability with litigants to be able to relate to what it is that they're staying for it, and certainly people that come from the LGBT community, close to, without exception, have encountered discrimination in their lives, and often many assumptions, heteronormative assumptions, for example, and that on the whole tends to make them more empathic when they encounter litigants, not just necessarily LGBT litigants, but other diverse litigants that may have had experiences very similar to that. And certainly one of the goals is to have a judiciary that looks like the state of California. And certainly in the state of California, there's lots and lots of LGBT people. So it's I think from our point of view, it's a positive.
Great, thank you so much. Judge Chilton, I wonder, so since, as you said, you've just been on the bench for a short period of time, I wonder if you can talk a little bit about how, from your perspective, people should think about their career if, as an ultimate goal, they'd like to become a judge.
Sure, I can give you the example of my own background, which now that I'm on the bench, I look around and I see that a lot of people came from government practice, a lot of DAs and public defenders, and because they actually are in court and they spend a lot of time in front of judges. So I think they are drawn to that because they see what that career path is. I started in private practice a long time ago at some big law firms where I represented, big corporations in super exciting trade secret litigation and other things. Sorry, it wasn't that exciting. And after I'd been at 2 different larger law firms, I went in-house to Warner Brothers, where I was for 24 years. And so I did litigation in-house, which really means I'm supervising outside counsel and trying to balance the interests of the company with, trying to win litigation, but also not at some crazy cost or making bad law. I did that for 24 years, and then I went to Netflix, where I also did litigation in-house. So I don't think that's the most traditional path to the bench, but I think it shows how open-minded Governor Newsom is, and actually Justice Jenkins, when they're looking for candidates. I also think it was a really good preparation for being on the bench, because when you're in-house, you have to weigh so many different things. Like when I was a outside litigator, my job was just to win, do whatever you could to win. Still trying to keep in mind the facts and the law if they're not on your side. But when you're in-house, you have to take into account so many different things about, is this going to be super disruptive to the company? Is this about your company case? Are we going to end up making bad law that's going to affect us for years to come? And so that actually ends up being a good set of traits for being a judge, because you have to take so many things into account. And I think other people will talk about their background as well, but I know that we have another judge who came from nonprofit. She worked for, I think it was United Friends of the Children or Alliance for Children's Rights or something. So that's a very different background as well. So I think in terms of, trying to figure out what is exactly the right path, I don't know that there really is one. And I suspect that Judge Hansel and Justice Lavin can also build on that.
All right. So actually, Justice Lavin, I was going to ask you, how is the appellate court different, and are the backgrounds of the people different?
Right. Well, my own background is I've now been on the Court of Appeal. It's going to be 6 years in July. Before that, I was on the trial court for about 13 and a half years. I think depending on the governor, it turns out most people that are on the Court of Appeal actually were trial judges, although that's not a requirement at all. And in fact, I was just looking at some of the bios for some of the other justices in our state. And for example, in San Francisco, in the First Appellate District, they have 20 justices. 6 of them never served as trial court judges before they were appointed to the Court of Appeal. Governor Brown appointed 4 justices to the California Supreme Court. None of them had ever served as judges. So I think one thing I'd like to bring across is that you don't have to be a trial court judge to serve on the appellate court. And before I became a Superior Court judge, I was appointed by Gray Davis, so you can see how old I really am. I had no criminal experience whatsoever. I actually was a volunteer at the city attorney's office for a couple of months, where I think I tried 3 or 4 misdemeanor trials, but I had almost no jury trial experience and no criminal trial experience. So I don't think that is a minus. I think the governors are interested in appointing people that are intellectually curious and are willing to learn. So I don't think the fact that you didn't have a lot of trial experience, I think as Judge Chilton just talked about, serving in-house, these are not disqualifiers. And if you're interested in the appellate bench, you don't have to be a trial court judge before you're appointed to the appellate bench.
Well, thank you so much. Judge Hansel, since we're talking kind of about mechanics, I wonder if you can say actually what the actual steps are for someone who's interested in doing this. What is the process?
Certainly. Well, of course, the first step with it is the completion of the application. And I know it's been on the chat feature, the link has been there, but just so you know, you go to the governor's office website, there is a place there where you've got the application. It is an owner's application, and it's designed to be that way for several reasons. One, they don't want somebody who just casually thinks they want to be a judge. They want people that really want to be judges and are willing to put in all the time and effort to answer each of the questions that are on the application itself. We want to, and obviously we're interested in the content of it. What is it they say, and how do you say it? as well. So that's step one, is to complete it. And it's a multi-month process, if done well, for you to complete your application. The applications then go to the governor's office. There is a judicial appointments staff, there's judicial appointments secretary, a brand new one, Luis Cespedes, who had had a career as an attorney in Sacramento, and a career of really working with in predominantly in the Latino community, but others as well, really promoting diversity and getting people, qualified people, to become attorneys and onto the bench. And then he has several assistants who work with him. They review the applications, and then they make a preliminary cut from them. Then the people that that they've decided to pursue further then come to the group that I'd mentioned before. It's called the Judicial Selection Advisory Committee. It used to colloquially be known as the Secret Committee, and it's no longer a secret. One of the things Governor Newsom decided with it is to identify who are the members of it. We're all appointed by the governor, and it consists of judges, appellate justices, and some people from private practice. We then review the application, and we conduct interviews of various people that are identified in the application, plus others that we think may know the applicant. So it's a so, for example, the last person whose candidacy I reviewed, I interviewed about 25 people to talk about it, and this person. We then prepare a report that summarizes the application and summarizes the interviews. And then we also, we attach to it a summary of each of our interviews. We make recommendations to the people on the committee itself. We then meet in the whole, having then reviewed the applications, and decide what our recommendations are and why. That then goes back to the governor's office. The governor's office then takes a subset of that group and sends it on to Jenny committee, and also in counties where it's relevant, which it is in LA County, for example, to the judicial review committees from of the various county bar associations. Those groups then conduct their reviews, which includes, unlike us, they will meet with the candidate as well. And of course, by the time they will have met with them, they have quite a number of recommendations. So for example, they've had, Jenny will ask you for, as a candidate, 75 names. They'll reach out to all 75 of them, and they'll get feedback. So they'll have some very specific questions. They then make those recommendations back to the governor's office. And then the governor's office, as need arises, will then make appointments, but based on that process.
So it's amazing to me that anyone makes it through that process in a way. But I guess I'd like to focus on sort of the opposite. Is there anything that would disqualify you sort of right off the bat? Judge Chilton, I wonder if you can address that.
I think felony murder, probably. I think, you know, more than anything, it's about how you conduct yourself over the course of your career. So it's all about your demeanor, how you've treated people, because the governor gets so much information from so many different people that they will have an incredibly detailed cross-section of people in the legal world who have, you know, had run-ins with you or not. So I don't think anything would really disqualify you, other than, you know, how you've conducted yourself as a lawyer in your practice. And then, of
Well-
course, felonies and, drug and alcohol addiction, I think, is also probably highly problematic.
So what about things like whether you were a trial lawyer? I mean, obviously you spoke about your own experience in terms of being in-house, but as a realistic matter, do you really need trial experience, where you went to law school, things of that nature?
Well, my esteemed colleagues on here, I think both went to T14 law schools. So I did not. I went to the University of Iowa. And I know that Governor Newsom has really focused on not requiring people to have gone to Ivy Leagues or T14 law schools. So that the law school you go to, I don't think is as important as it used to be. In terms of, what was your other question? Oh, trial experience.
Trial experience.
Well, I know Judge Hansel described his experience. Oh no, it was Justice Lavin who described his experience with the city attorney's office. I had a similar lack of trial experience. I did do a jury trial early on in my career, and afterwards we lost, and the jury said they felt really sorry for me because I was so bad. So it's nice to have trial experience because you have a better understanding of how the process works. It's also good to have jury experience. So if you get called in for jury duty, definitely go through that process. But I don't think it's not the most important thing. It's nice to have it, but you definitely don't need to have it.
Thank you. So Justice Lavin, I don't know how to ask this in a nice way. We have a Democratic governor. We've had Democratic governors recently. What if you're a Republican? Or what if you're a decline to state independent person? Do you think, does that make a difference?
I think probably Judge Hansel has a better sense of whether that matters. I would think, I mean, as a practical matter, when they make the announcement as to who the governor is appointing, either to the Superior Court or the California Supreme Court or the California Court of Appeal, it will state your political preference, or including decline to state. I mean, I think historically in the last 20 years or so, governors who happen to be Democratic would probably appoint mostly Democratic people to the bench, but not necessarily. And I think when Schwarzenegger was governor, I think he went out of his way to appoint both Republicans and Democrats to the bench. So I think it just really varies on the governor. I mean, as a practical matter, this is a Democratic state. We do have a Democratic governor. I think most appointments, if people, unless they decline to state, are probably Democrats, but certainly there are Republicans that are appointed to the court as well. So.
Judge Hansel, I wonder if you can weigh in. Sorry for the being muted.
That's quite all right. Let me amplify what Justice Lavin said with that. First, the official statement and then in practice are both consistent with that. I recently, the Secretary Cespedes spoke to the members of the Judicial Selection Advisory Committee, and I got a chance to ask him two questions. One was that question. And his response was that it makes no difference as a practical matter whether you are a registered Democrat, registered Republican, a decline to state. He did note, which would make sense also, obviously, if you took an extreme position, which could be in any party on something, that could be relevant for it. But mere party affiliation itself is not a disqualifier, or a decline to state is not a disqualifier at all. In practice, when we've reviewed applications, the party affiliation of the applicant is irrelevant to us. I really, even in the summaries, even in the very formal summaries with it, I don't remember seeing one where it said, so-and-so is a registered Democrat or registered Republican or declined to state. It just doesn't come up in our conversations. And there are on the bench on it, frankly, while I do know the affiliations of a number of our colleagues, there are many I don't know on it. The issues really just don't come up.
So what about age and other kinds of things? I mean, as someone with a white beard, it would be interesting to me to know that question. And if I were at the beginning of my career, what are the requirements that we have, or you'd like someone to know before they're thinking of becoming a judge?
I mentioned I asked 2 questions. And that was my second question to the Secretary Suspettus, what about age? And again, he said that was certainly not a factor, and we know it was not a factor with Governor Brown. And if you look at the actual appointments, now you will see that they've definitely appointed people in their mid and upper 60s to the bench. Certainly a question on our minds is, how long do you want to do this? And if somebody only wants to do it for a few years, 4 or 5 years, let's say, that's going to be less interesting. But I think the fact that somebody's appointed at, let's say, age 65, that's not a problem.
Judge Chilton, did you want to weigh in? I saw you unmute yourself a little earlier.
No, I was just going to say I was just appointed and I'm 61. So obviously age is not a huge barrier.
Is there a number of years that you have to have been a member of the bar, on the other hand, at the other end of the age spectrum?
I think Judge Hansel knows this, but I think you have to be at least 10 years out.
Right, that's my understanding. Justice Lavin, is there anything different that you would add about the appellate bench in terms of what you think qualifications or disqualifications are?
I mean, I think you have to be interested in writing and editing. I mean, the job really is, it's very different than being a trial court judge. It really is primarily a writing, editing, and research job. So I think to the extent that's something that you're interested in, try to get as much experience either as a lawyer in terms of drafting briefs and appearing for oral arguments. If you're a trial court judge and don't have a lot of writing experience when you were a lawyer, I think it's very helpful to have an assignment where you're writing a lot. Like it could be a family law assignment where there are lots of bench trials and you're the trier of fact and you tend to write lots of statements of decision. But it's just a very different job. And a lot of it depends on your personality. If you're someone that likes lots of interaction with the public and lawyers on a daily basis, that's not the Court of Appeal. We only have oral arguments 2 days a month. So we don't even interact with the public for 28 days out of 30 days of a month. So it's just a very different job. So I think it just depends in part on your personality and what you're interested in.
So, Judge Hansel, what would you, since you're speaking to people who are interested in becoming a judge, what would you tell these folks that are let's say, the 3 most important things to think about in terms of having this as your career?
Well, number one, about being a judge is unique. And there are certain things that everybody else enjoys as just privileges, and you give them up voluntarily as a judge. We do not engage in political activity. For example, so I can't write a letter to the editor saying I'm endorsing so-and-so for a particular office. We really unplug from that. You unplug from social media. You really are judged 24/7. So there's a lot of things that way you have to think about that. Is this really what you want to do? with it, because I think that Judge Chilton mentioned that about the issue of judicial temperament. It's critical for that. And so that's certainly one. A second thing is public service. If you were thinking about becoming a judge, public service is important. And we look for a commitment to public service over a number of years. So if you're applying right now on it, it doesn't help that all of a sudden you've sent $100 off to a charity or something like that. So plan with that, and they really look for much more of a commitment to it. And number three, as I said, challenge yourself. Don't worry if you think, oh, well, they'll never select me because I went to a local law school. They'll never select me because I don't have a lot of trial experience, or other things. That they won't select me because 20 years ago I was picked up for DUI or possession of marijuana, that sort of thing. Those are not disqualifiers. You want to make sure you disclose those, but otherwise that's okay. And if you think one person might have some harsh things to say about you in opposing counsel, don't let that be a disqualifier too. Obviously, if you have a trail of controversy that way, that may be more of an issue that we're going to look at with it. And we get some people that way, where it's just, there seems to be one issue after another that way, or a lot of disciplinary problems with the state bar, what have you. Those are things that are going to be factors, but there's some things that aren't real barriers.
So, Judge Chilton, it seems to me from listening to you all talk that having a mentor would really be a useful thing. Did you have one, and what do you think about that?
I did have one. It was someone that I practiced with many years ago in civil practice. He is on the bench. He is LGBTQ, and we've been friends for a long time. And when I started to be interested in it, I contacted him, and he was incredibly helpful in terms of encouraging me to apply, helping me a little bit by explaining what the questionnaire is like. He didn't give me very much information about how long my answers should be or anything. And I later was, one group said they thought my answers were too short, and another group said they were just right. But it was really nice to have somebody kind of walk me through the process and then give me feedback every once in a while, because it seems a little like a black box, like you send your application in and you hear nothing for a long time. But it's nice to have somebody who can kind of give, every once in a while give you some feedback and tell you what's going on. So
how do you get this mentor if you don't happen to have a former colleague who is now on the bench, etc.? You contact Judge Hansel and Justice Levin and me, and we will try to put you in touch with somebody who can help you. Great, thanks. Justice Levin, is there anything you would change in your colleagues now that, on the appellate bench, or someone who's targeting that?
You mean somebody who wants to
become an appellate justice, right? Go on the appellate bench. Are any of the things that were said, do we need to shift or change them because the courts are different?
I don't think so. Just to sort of follow up on what Judge Chilton was saying, before I was appointed, I didn't know a lot of judges, and I really reached out to judges through third parties that I knew were either on the bench or had retired recently who were LGBTQ, and they were very helpful to me, sort of explaining really what the job was and making me really think about, is this what I want to do? And I think Judge Hansel also talked about, when you become a judge or you become a justice, you have to leave certain things behind. You can't be on social media. You can't be a political player. And really talking to other LGBTQ judges about their experiences of what the job was really like. And when I was first appointed almost 20 years ago by Gray Davis, the world was very different. I think it was much more difficult to be an out gay person, or if you're a lesbian 20 years ago, then certainly it is now. I think now it's a real plus in terms of diversity, and the governors have all been in the last 20 years, have been very committed to diversifying the bench. So I would say to anybody who's interested in the appellate court or on the Superior Court, because I've done both jobs, really reach out to us. And I know at the end of this broadcast, our emails will be given out. So if people have any questions, if we can't mentor you for some reason, or we'll be happy to have you contact someone else that can help mentor you. But I'm always happy to help review applications, help people understand the process to the extent I can provide any guidance.
Well, actually, so that prompts me to ask a follow-up question. Judge Hansel, given this application, which sounds pretty like an uphill climb, I wonder if you can give us a little bit of insight as to how you think you should approach it and what might be useful advice.
Take it seriously. Spend the time on it that it deserves. What I did, not necessarily the only way, was I would prepare answers to questions. I would then close the application. I'd come back to it. I'd reread them. I would revise them. I would share them with several colleagues to get feedback. I'd read it again. I'm sure by the time I press send with it, I probably read it a dozen times and had several other people look at it. And then of course, when I went back and read it subsequently, I had a couple typos that I wish, instead of having read it a dozen times, I wish I'd read it 15 times to really go through it and make sure it's internally consistent as well, and that you've fully disclosed things. If you had disciplinary problems, make sure that they're in there. If you have your career path has some unexplained time periods, why is it? There may be totally good reasons why. It just sparks questions, and go through, make it tight as well on it. Just remember, it's that if it's a verbose application, it's harder to get through that way. And so, as I said, we're interested both in what you say and how you say it.
Well, so Judge Chilton, you said that one of the comments that you got was your answers were too short and others were just right. Just briefly, what were they? I mean, how long were they, given that Judge Hansel was talking about being verbose? You remember?
I'd love to hear what Judge Hansel put down for his were. I mean, you are asked to talk a lot about yourself and your career and why you think you're a good candidate for the bench, and it's kind of hard to do that sometimes, and at the same time, sort of balancing, a desire to be humble about your own background. So I would say some of my answers were maybe 4 sentences. And I got the impression from one of the groups that interviews candidates that it should have been multiple paragraphs.
Judge Hansel, do you think that's right? And then I want to ask Justice Lavin whether there's something different for the appellate court.
No. Well, of course, when I reviewed Judge Chilton's application, I thought, oh, this is how an application should look. It's just perfect. We don't, when we go through them on it, it's just the length of it is just not a metric that we look at all. It's much more the substance of what's in it, and that's, as I said, that's the advantage of writing it, putting it aside, bringing it back, because you'll remember some things that you may have left out previously. But certainly sometimes if it's very short, this may be indicative of somebody that just did a slapdash job with it. So it really is, it merits careful thought and review when you put it together. And certainly one thing that I do with editing a lot is I get everything in there, and then I go back and see how I can give the same message and reduce the number of words that I have so that just to make it much tighter. And I suppose also, I mean, have it visually so it looks interesting as well. So instead of one long paragraph, perhaps you break it down into multiple paragraphs.
Right. So Justice Lavin, is the application process or the application itself different on the appellate courts?
It is slightly different, and for the appellate court, there's one application if you're an attorney to be on the Court of Appeal, and another for if you're a sitting judge. One of the things that is required is if you're a sitting judge, you have to list all of those opinions where you were reversed, whether even in part. So that takes a lot of time. And I remember, just to sort of let people know in terms of the black box and how long this process takes, I think it took me 2 years from the day that I first applied to when I was appointed to the California Court of Appeal. So along the way, I had to update my application several times. So it was a long process, and people shouldn't be discouraged by not really knowing what's going on. I think it's beneficial, particularly for the appellate court, if you update your application periodically, if you've had significant cases or something else has happened that would be of interest to the governor's office. The actual process of getting appointed to the Court of Appeal is pretty similar. I mean, you still go, it's very governor centric. You still go to the Jenny Commission, although I think I had 4 investigators versus 2 for the Superior Court. And then even after the governor publicly announces your appointment, you have to go before, it's called the Commission on Judicial Appointments. And that's a public hearing where people can actually actively come and testify for you or against you. And the commission, which consists of the Attorney General of the state of California, the Chief Justice of the state of California, and the most senior justice in your appellate district, they actually vote on whether to accept the governor's recommendation. So it's that extra step, which, to be honest, I really didn't quite know about when I first applied. And it was fine, but the whole process takes a really long time, and people shouldn't get discouraged by it. And your name is out there. So lots of people are vetting you in my case, for quite a long time.
Right. So actually, one of the mentions there was the Jenny Commission. Just for people who don't know, the Jenny Commission is what, and what role does it play?
It is, my understanding is it's part of the state bar, and that is a formal commission that actually formally vets you, and they make they actually come up with they rate you. They tell the governor whether you're qualified, not qualified, well qualified, exceptionally well qualified. That goes back to the governor. The governor can still appoint individuals that are not qualified, although they rarely have done that, but then it becomes public. So it's a formal vetting arm of the state bar that actually, they get the list, they get your application, they have the list of all the references, they will contact those references, they will interview you. I don't know, Judge Chilton was the most recent one that went before Jenny. I think they still tape record your interview they did for me, which is a little bit off-putting. And then they come and they'll discuss if people said bad things about you, they'll ask you about that. You'll have an opportunity to respond. So it's a pretty intensive vetting process.
Judge Chilton, is that true? Do they actually still tape record you?
I did all of my interviews on Zoom, and they asked to tape, record the entire thing. So they also have you on screen.
So what was your time period? Justice Lavin said that his is about 2 years. Do you remember? I mean, I'm sure you remember, actually.
Yeah, I think we could probably all cite the day we sent ours in and then when we heard. Mine was a little less than 18 months, so I think it was about 17 months.
And Judge Hansel? I'm sorry.
Mine was about 11 months from the moment I pressed send to when I got the phone call.
So you're on the no longer secret committee. Is that 2 years, 11 months, somewhere in that time period? What your impression is the normal process?
It's all over the map on it. It's just that I think that mine was probably on the fast side at 11 months, but I know several people that who are now on the bench who waited about 4 years for it, and it's just a lot of it is on an as-needed basis, and usually they hold up is at the very end with it. In other words, we have certain time limits within which we'll review applications. Similarly, Jenny, when they get them, have a time limits when they'll review them as well. But the governor, we usually appoint people in batches, and it's a matter of what else is going on at that time with the governor, how much time that the judicial appointment secretary has to spend with the governor. So it's just that, and there's not much you can do about it either. And certainly one thing that Justice Lavin said during that time period that also applies for the trial court, and that is to update your application. The advice concerning that is use discretion, don't update it for minor things, and don't update it too often. But I think I did in that 11 months, I think I updated it twice. I wrote a couple articles that got published, I got an award. It was that sort of thing that I included in the applications. It just sort of says, here I am, and it keeps it current.
So panelists, we have a number of questions from the audience, and I wonder if we can address some of those. So one of them is there a way around this whole appointments process by simply running? Because there are judicial elections. I wonder if you can tell me the sort of relationship between those two means of becoming a judge.
Well, I guess I can start on it, and that is the way the state law works is if an incumbent decides to retire on the exact date that their term is up, then there is a judicial election for it. Most judges don't do it that way. Most judges announce their retirement whenever they want to announce it. That then creates a vacancy that the governor's office can then fill. There are judges serve for 6-year terms. You then can complete papers to indicate you wish to re-up. Rarely is an incumbent judge challenged, but it doesn't say it doesn't ever happen. If a judge is challenged, then there's an election for it. Otherwise, though, if there is a vacancy because the incumbent decided to wait until the exact day that their that their term is up, then the office is considered open, and people then run for it. And it's a elaborate process. There's lots of time periods involved in doing that, and you're running a countywide campaign. If you think about it that way, that is just judges run countywide, and so it can be an expensive process. But every time we have every 2 years, we always have several people running, or several races that way. We had it that way last year. So I don't know if either of my colleagues want to add anything to that.
Well, I'll ask them. Justice Lavin, did you want to add something?
You can't run to be on the Court of Appeal or the California Supreme Court. You have to be appointed by the governor.
Okay. Right. So one of the things that we haven't talked about is the sort of intersectionality aspect. LGBTQ plus obviously is one group of people, but what about people of color? Are you aware of judges in California who are themselves both members of the LGBT plus community and also a person of color? I wonder if we have any numbers on those or data on that. And you may not.
We may have numbers. We definitely have examples of it, and of course, our nicest example right now is our newest Supreme Court Justice, Justice Martin Jenkins. But there are, first of all, just in general, there are lots of judges of color, and more all the time, and it just proportionally there are we have LGBT judges of color, and certainly Los Angeles and San Francisco and in San Diego, and I can't speak for other counties, but those three I know that we do.
So I have a question about the mentor program. So Judge Chilton, you mentioned that getting a mentor would be, in part, one step would be to talk to the three of you. But is there another, or not another, but is there a better way to start this process so that you can build this relationship with your mentor in the most effective way? I wonder if you can talk about starting that relationship.
I think probably the best thing to do is to start by getting a mentor, and that mentor will introduce you to other judges as well, because it is good to get a lot of different people's points of view, both on your application, what each judge's experience is in the different courts, and what their experience is in terms of, you know, what it's like to be a judge 24/7. So I think the mentorship program, I think, is designed to give a mentor for a potential candidate, but then for that mentor to help introduce them to other people who could also provide some a broader experience. And
Justice Lavin, would that also be true for people seeking an appointment to the appellate bench?
Oh, absolutely. And one other thing is, I don't know how many people are listening in that might be in law school, but also consider an externship on the Court of Appeal. All of the law schools, including UCLA, have externship programs where, in lieu of taking a particular class, you can be working with a justice in their chambers, helping draft opinions. And that's a wonderful way to get to know the process, get to know judges and justices, and really helping to contribute. So I think for people who might still be in law school, really look at the possibility of working as an extern during the school year.
Right. So I have a question here in the chat that is connected to the process specifically. So the question is this: once you have submitted an application, will you know whether and when the Regional Judicial Selection Advisory Committee has considered your application? So that's part one of this question.
The answer is no. We are the work we do is all confidential. That's one reason we don't contact the applicant, so anything we do is simply between us and the governor's office. If you start getting or you start hearing from your friends or people you've identified as part of your list of 75 that they've been asked to fill out a form, you'll know we have already considered it and it's gone on to the next step.
And it sounds like that's different than from the Jenny Commission, which is in fact public and you're aware, other people are aware. Is that accurate?
Yeah, that's correct. I mean, with Jenny, it's more of a public process, and as Justice Lavin said, Jenny is a creature of statute, and so they have certain procedures that they need to follow. Now, the interviews they do are not public themselves. That they will do them one that. Those would simply be the interviewers, called investigators, and the applicant.
Right. So I have a comment from another LGBTQ judge, Judge Zeidler from LA Superior Court as well. And he offers himself in the chat is his contact information as well. But he also says that an overwhelming majority of LGBTQ plus identified judges in California are white, so that BIPOC LGBTQ plus applicants are highly encouraged. Do you think that that's accurate? I assume it is, but.
That's the whole purpose of this program, is to try to get as many judges, diverse judges as possible, and certainly intersectionality as is very high on our interest list. So having judges who are LGBT and who are of color is something that we very much would like to see.
Yeah, I assume so. So there is a question again about the mentorship program. The question is the mentorship program meant really for those candidates who don't know any judges personally that they could ask to be a mentor, or is it for anyone, whether you are familiar with judges sort of either as a professional thing or outside in the outside world? I don't.
Well, I'm sorry, I don't mean to do that to hog the stage, but it's intended for both. And it's certainly, if you know judges already, by all means, reach out and contact them with it. And there may be some things that would be duplicative, but there's really no such thing as too much advice. So they could consider doing both.
Well, actually, so on that note, we have about 2 minutes left. I wonder if there are some final words that you might have for people considering. And Justice Levin, I wonder if we can start with you and then.
I just want to encourage people to apply. I mean, the process, notwithstanding how long the application takes and you may not hear for a while, it's a wonderful job. You're doing really important work. And you are doing real public service. So notwithstanding, it's not always wonderful. It's almost always wonderful. And so it's really worth the trouble of applying. So I really encourage everyone to apply and just to hang in there and not be discouraged, even if you haven't heard anything in 2 years till you get that call. So.
All right. Thank you. Judge Chilton, do you have anything you'd like to add?
I would just encourage people to look at the application to see what the requirements are for information. And when you're going through it, think about the most important cases you've worked on, the most significant. And, in your spare time, make a list of people that you can include on your list of people to contact. It takes a long time to come up with 75 or more people. I think probably most of us came up with more than that. And all of them are contacted. So start working on those lists, and it'll take a long time, but it's certainly worth the effort.
Thank you. Judge Hansel, I'll give you the last word.
A couple things. One, when you press send and you have applied, expect it's going to take quite a while. Go about living your life the way you do, and within certainly what I did with it is I thought, all right, there's no guarantee this is going to happen. I have a great job. I really enjoy what I'm doing, and if it doesn't happen, I'm fine with it. So don't put your life on hold while your application is pending, because it under the best of circumstances, it takes a long time. And again, think about this commitment to public service with it. That's what being a judge is about. And we certainly are looking for people that have a great track record with public service. And that's a broad definition. It may be that your family responsibilities, et cetera, take up every waking hour. So there may be service that way may take on a different definition with it. It doesn't, not all of us have the time to be able to go out and handle cases for Lambda Legal Defense or work with the Williams Institute or whatever it might be with that. But so there's a wide variety of things, but nevertheless, that's an important factor.
Well, thank you. It's been a really interesting conversation, and it sounds like we should continue this, and I hope people will contact you and start the process. I'd like to thank each of you for participating in this panel, and thank the Williams Institute as well as the International Association of LGBTQ+ Judges. Thank you so much.
Thank you.